Probate and Trust Litigation Timeline. Hi, I'm Darren Findling of the Probate Pro Law Firm, and we regularly litigate probate and trust disputes. And I think it's really helpful for people to have a general understanding of the timeline for the litigation that you may be involved in. What's really important to understand is that each case is unique. This is just a general framework, a general understanding of a typical timeline. Each case will have its own timeline that will be set based on the facts, the law, and of course, the court's scheduling order. I think understanding that when you're involved in a litigation matter, it's very time consuming, it can be emotionally exhausting, and of course, and unfortunately, it can be expensive. Let's jump right into the general timeline that exists when you're involved in a probate or trust matter. First, there's some beginning, and that is usually a lawsuit is commenced. It may be a petition, but it's generally a lawsuit, and there is a filing of a complaint. When that complaint is filed, the next thing that happens is you have to serve that complaint, that action, that petition, whatever it may be, upon the parties that are being affected by it, as governed by the court rule and the statute. So service a process to get jurisdiction over those individuals, what we call personal jurisdiction, is a requirement so that they have notice of the existence of the action of which they're a part of. When that occurs, there's some response that occurs. Usually it's an answer to the lawsuit, an answer to the complaint, but it could also be a dispositive motion in response. Depending on the court rules and the circumstance would dictate what that responsive document looks like. It may be, as I said, an answer to the complaint. It may be a dispositive motion or some other motion asking the court to take some action. Generally, the next thing that occurs is this phase we call discovery. Discovery can include depositions, interrogatories, subpoenas, requests for admissions, requests for documents, with the idea being that both sides should have a clear understanding of what the facts are that are about this case that is before the court. And that's why these types of discovery, opportunities to learn about the case, occur. And again, these are governed by court rule and statute and case law, and every single state and jurisdiction kind of handles this differently. And of course, the court or the judge may have specific rules about how that discovery will occur. But the general concept is that both sides should have sufficient information to understand the facts and circumstances relating to the lawsuit and the case that is before the court. Generally, the next phase of this process is that the court may have you participate in what we call alternative dispute resolution. It could be case evaluation, it could be mediation, facilitation, all different forms of dispute resolution can be employed. The idea being that short of having a trial, whether it be a bench trial or a jury trial, the court is trying to encourage the parties to resolve the matter. We know that it is expensive to litigate. It's time intensive to do so. And the court wants to employ opportunities for the parties to reach a resolution, a compromise short of trial. Most cases, although on television you think most cases resolve at trial, most cases don't. Most cases get resolved well before trial for all sorts of reasons, typically because of the expense, time, and risk associated with litigating a probate or trust dispute. So the court allows for parties to utilize alternative dispute resolution opportunities to see if the case can come to close. And of course, after that has occurred or within that stage, there are motions that are often filed, what we call dispositive motions, motions where you're asking the court to maybe dismiss the case. Maybe you're asking the court to limit how the evidence will be presided at the trial ultimately. These are motions. Now, I know that in this timeline, the motions is written as if it's linear and it's afterwards. The fact is that these motions can be filed throughout the time frame of this case. So we're really generally talking about opportunities to try to dismiss the case that we're referring to here. But motion practice occurs throughout the timeline. And motion practice can, again, be very time consuming, can be very expensive, in terms of the litigation timeline. And then, of course, if the case doesn't resolve, you got a trial. Whether it be a bench trial or a jury trial, those determinations are usually set forth during this timeline and, of course, governed by the merits, or not the merits, but the facts and circumstances of the case and how you pled your matter, whether you're asking for a jury trial, whether a jury is allowed, not allowed, etc. So there's a trial, and then the opportunity to bring forth your case before the trier of fact for a resolution of your case. What we know is that probate and trust litigation is exhausting, expensive, all the things that I've been talking about. But this gives you a general framework to understand the timeline. Now you'll notice I didn't put any dates here, because sometimes you get from the lawsuit or petition commenced to a trial or an evidentiary hearing very quickly, within a short frame of time, depending on how the court runs its docket. And sometimes it takes a very long time, a year, 2 years, whatever it may be, for purposes of getting there. So there's no dates here because it's dependent, again, on your particular circumstances of your case. But at some point, there'll be resolution and the case will then come to close. If you've got questions about probate and trust matters or litigation or the general litigation timeline, feel free to reach out to the Probate Pro at 833-PROBATE or visit us at theprobatepro.com.